Good morning. For those who don't know me, congratulations. My name is Tom Fair. I'm a partner with Thompson Hine. With us today presenting is Jen Roach and Amy McClurg, also of our Office of General Counsel. Welcome to the annual 2.5-hour complimentary professional conduct and ethics seminar. This program is intended to highlight ethics-related issues relevant to all practitioners. Presenters will cover both common and evolving issues regarding the unauthorized practice of law and multi-jurisdictional practice. Presenters will address issues pertaining to the Corporate Transparency Act, which is a matter of particular relevance to all attorneys as their practices carry over to 2024-2025. Presenters will also discuss pervasive issues that impact all legal communities, including discrimination and artificial intelligence. So what fun. Before we begin, I have a few housekeeping items and disclaimers. Today's program is being recorded and we will send a link to all attendees within 48 hours of the presentation. The presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of the individual speakers only, especially Jen, and do not necessarily reflect the opinions of our clients, affiliates, or Thompson Hine. The content should not be taken as advice, as the views expressed are for informational purposes only. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can, both during the presentation and at the end of the webinar. If we don't get to your question, we'll follow up after the program by email or phone. Live questions can be posed by those attending in person in Cleveland, Chicago, or Dayton. We will be offering CLE credit for today's webinar. Please be sure to complete the verification of attendance survey. A link to the survey is included in the agenda that can be found in the handout section of the control panel located on the right side of your screen. Did you all follow that? Okay, good. I did not. We will also paste the link in the chat at the end of the program. I will announce the tracking codes after each presentation and at the end of the program. In the handout panel, you can download a copy of the PowerPoint slides as well as the bios of our speakers. A survey link to the evaluation form can be found on the agenda in the handout section. Please be nice. After you submit the verification of attendance survey, you will receive a personalized CLE affidavit form from the MCCLE Thompson Hine at AmericanBar.org for this program. Please check your spam or junk folders as these emails often end up there. Once you complete the affidavit, well, that's not a comment on the ABA, by the way. No, we don't all think they're junk. Once you complete the affidavit, you will be able to download your certificate of attendance. It will be emailed to you as well as from the AmericanBar.org address. The ABA will submit your credit request to the states you requested on your affidavit, if allowed, and will update you on the status of the state approvals of credit. For those attending in person, please do not forget to sign in and out. We would appreciate it if you could take the time to complete the evaluation form on your table. Okay, that's all my disclaimers. Let's get started. Today, we will start with our newest member, Amy McClurg, to talk about ethically navigating social media.
All right, good morning, everybody. I'm Amy McClurg, and I'm going to be starting off this morning's CLE talking about the ethics rules that all attorneys should know about when they are using social media. So I'm going to try to discuss as many rules as possible, but this by no means covers all rules. There's so many rules to cover. I'm going to just kind of scratch the surface with a lot of them, but I will try to go into detail as much as time permits. So as you all know, you are subject to the rules of professional conduct. These are what we call ethics rules. So you're not just subject to the rules in the states where you're licensed, but also you can, your conduct, especially with social media, you can subject yourself to the rules in states where you're not even licensed. So we're going to use the model rules rather than any specific state. We're going to be discussing the Chapter 1 rules that covers the rules that govern the client-lawyer relationship, so confidence, your duties to former clients and to prospective clients. We're also going to be talking about the conduct with persons that are non-clients. So 4.2 is the no contact rule, and 4.3, this deals with non-clients but that are actually unrepresented. As far as the Chapter 5 rules, we're going to be focusing on the unauthorized practice of law, but also what your duties as a partner or supervisory lawyer could be. And your Chapter 7 rules are going to be the rules that you want to pay attention to when you're thinking about marketing or advertising your services. And the Chapter 8 rules are going to be the rules that govern the maintenance of the integrity of the profession. So we're going to be mainly talking about general misconduct. So your rule of competence, not surprisingly, the first rule says that attorneys need to provide competent representation to their clients. This is why it's important to always read the comments to the rules, because the model rule has comment 8, and so does Ohio, which says in order to maintain your requisite level of competence, you need to keep abreast of the changes in the law, and that includes the benefit and risk associated with relevant technology. So with regard to social media, there's an ethics opinion out of the District of Columbia that says, essentially, in order to be competent in your use of social media, you have to at least be conversant in how the networking site works. So the big focus here is going to be on privacy settings. So you're going to want to be aware of when you are viewing somebody's profile, whether or not somebody can actually see that, whether or not you can send a friend request or a request to follow or connect, those types of things, as those are going to implicate other ethics rules. So this rule is I mean, all the rules are important, but this one is a big one. So this is your duty of confidentiality. And as you can see, Ohio has similar wording, not exact, but similar wording to the model rule. But the main phrase that you want to look at is that you shall not reveal information relating to the representation of a client. So that's going to be, you know, the buzzwords here that you're going to be looking for. And with a lot of these rules, there's more than meets the eye. So of course, you know that you can't take to social media and you can't go on and even though you feel that you did a really good job and you want to market your services, you want to broaden your book of business, so you want to talk about how you represented client X and what a great job you did. Obviously, you can't do that. But can you do that when the information relating to the representation is a matter of public record? Generally speaking, no. And the American Bar Association has issued an opinion that says as much. So you may not reveal information relating to the representation, including information contained in public record, unless it's otherwise authorized. So if you can't talk about information that's in public record, can you at least talk about your client? Can you at least reveal the name of your client? Maybe it's a very prominent client and you're you know, you're thrilled to say that you are representing or you've represented this client, and you want others to know so that they know that you're worthy of being their client, or excuse me, their attorney as well. So can you at least reveal their identity? Generally speaking, no. So as the New York State Bar Association opines, the lawyer may include the names of the attorneys that they, or excuse me, the clients that they have represented, but the client must actually give consent. So without this consent, a lawyer can't identify the identity of a client or the fact of representation if this constitutes confidential information. So a few takeaways with regard to this rule. The fact of the representation can be confidential, and also you can, you know, so how do you get past this challenge? Well, you can be, you know, you can still be vague enough in using, you know, that you represent a large banking institution without actually giving the name, or, you know, a few key facts. But you have to be careful that you're not so specific that you are revealing, you know, but that by the information that you're putting forth, it actually reveals who the client is, even though you haven't named them. And that seems maybe a little far-fetched, but that's actually, it's happened, especially when, you know, somebody's blogging or, you know, they're making a lot of posts. Keep in mind that your duty of confidentiality does not terminate when the lawyer-client relationship terminates. The the nature of the rule changes a little bit, and you'll look at Rule 1.9 for that, but the duty of confidentiality nonetheless applies. And although I really want to focus on the rules of professional conduct here, there can also be a contractual duty that you have not to reveal the identity of a client. I have seen an increase in the amount of outside counsel guidelines that explicitly, where the client explicitly says, you may not use our name, our company's name, in advertising or marketing materials without our consent. So you want to pay close attention to engagement letters or other documents that are governing the representation, because they may, they may take any doubt in your mind away that that's actually the case. So we're going to talk now about Model Rule 1.9, and that governs your conduct with regard to former clients. So you can't use information that relates to the representation, that's the key word, to the disadvantage of the client unless the information has become generally known. So generally known actually doesn't just mean that it's a matter of public record. There's more than meets the eye to even that definition, and there's an entire ABA ethics opinion about that. You also can't reveal information relating to the representation. So we're going to go to our first example here. This is a recent example that's out of Colorado, and this attorney was hired by the town of Monument in Colorado to investigate whether or not the town was allowed to reimburse certain election expenses. And so he was hired by the town to do an investigation and write a report. So he does this investigation and he finds that there's some facts that are pretty concerning to him. And so he writes this in the report, and he writes on the report, this is confidential, attorney-client privilege, attorney communication, all the hallmarks of protection here. But somebody from the town council actually leaked his report to the media. Before they could discuss before the town council and this attorney could discuss the details of the report, new council is elected, so we got a new group of people coming in. They are not pleased with what his report says, and things turn sour really quick. So he takes to Facebook to make derogatory remarks about the mayor and the townspeople and everything. Well, in doing so, he revealed information relating to the representation. Even though this information had been leaked to the media, he was still found to have violated Rule 1.9 because he had a duty to his former clients not to reveal information, and he took to social media to do it. So know that people are watching, and I can't remember who it was exactly. I think it might have been the mayor or one of the townspeople had turned him in, and so people are watching what you post. So certainly, certainly be aware of that. So we're going to talk quickly about the next rule, and that's going to be Model Rule 1.18. This rule governs your conduct with regard to prospective clients. So if you have an interactive blog, interactive website, you have some sort of interactive social media, a lot of conversations on LinkedIn take place, a lot of back and forth. You really want to be careful that, that you're not giving legal advice. So giving legal advice can allow a court to find that the person that you were talking to reasonably believed an attorney-client relationship formed, and then all of a sudden all of the duties kick in, and that includes malpractice. You can also disqualify yourself from taking a case that you may really want to by information that you learn. So just be careful how much you're interacting. Websites can have disclaimers that say nothing on this site should be construed as legal advice, or visiting this site does not create an attorney-client relationship. But if your disclaimers don't back up your conduct, then you're really not helping yourself out at all. So these are some examples of disclaimers that you could use. This isn't legal advice. Don't send confidential information to our attorneys without permission to do so. These are the types of these are the types of disclaimers that you may want to use. So we're going to next go on to the no contact rule. So this rule is what seems like to me it should be incredibly straightforward, but is absolutely amazing how many ethics opinions and how many issues have come up with regard to analyzing the wording in this rule, the terminology in this rule. But for purposes of social media, the word that you want to focus on here is going to be communicate. So, you know, a lawyer cannot communicate about the subject of a representation with a person they know to be represented unless you have, you know, consent from opposing counsel or the court. So communicating here is, again, the word that we want to focus on. So the District of Columbia has issued yet another ethics opinion that talks about our ethics, our ethical duties with regard to social media. And here they give a little context as to what this means. So when would the no contact rule come into place? So it could come into place when you're doing a social media investigation, which, by the way, sometimes is necessary in order to comply with your duty of competence. You can't just, you know, turn your eye and say, oh, I don't want to do this investigation. Sometimes it's actually necessary. So you need to know, again, going back to Rule 1.1 with competence, you need to know how the site works. You need to know whether or not you're viewing information that's just open to the public, or whether you're, whether you're looking at information that's private and you're doing that by requesting, you know, to be a friend or to make a connection, because that is considered a communication. So a lawyer's review of a represented person's public social media does not constitute a communication. So therefore, no contact rule is not an issue. On the other hand, when you are making that friend request to a person that you know is represented by counsel so that you can do your social media investigation, that's considered a communication, and then you're going to certainly implicate the rule. So Rule 4.3, so this deals with persons who are actually not represented, unlike the no contact rule. This is important because you may have to do social media investigation on them too. This can be jurors, witnesses, etc. And the rule is somewhat similar in the sense that, if information is public, it's pretty much fair game. But if you are requesting information, or I'm sorry, if you're requesting a connection, which generally you may not want to do, or in some jurisdictions you can't do, depending on if it's a juror, witness, etc. And it varies greatly from jurisdiction to jurisdiction. There's a lot of ethics opinions in various states that say what you can and can't do depending on who the unrepresented person is. But regardless, if you are allowed in your jurisdiction to make that friend request or that connection, there are going to be additional rules you want to look to, which is, do you just have to correct any misunderstanding that they are that you're not disinterested in who you represent, or do you, when you're making that friend request, actually need to say up front, this is who I am, this is who I represent, I'm not disinterested. So that's just going to depend on the jurisdiction. The next set of rules that we're going to talk about are going to be the rules that govern law firms, associations. So if you're a partner or you have comparable managerial authority, you need to make reasonable efforts to ensure that the firm has in effect measures that all the lawyers are actually complying with the rules of professional conduct. Similarly, a partner or an attorney who possesses managerial authority needs to make reasonable efforts that the firm has measures giving reasonable assurance that a non-lawyer's conduct is compatible with the lawyer. So both lawyers and non-lawyers alike. So how would you do that? How would you comply with these rules? Well, again, going back to DC ethics opinion here, having a policy in place. So, Thompson Hine has a very good policy in place, that addresses what concerns what conduct is acceptable or not acceptable when you're using social media. So for instance, a lot of attorneys are going to want to, use social media to market their services. But also you need to make sure that non-lawyers who may not be using social media for the same purposes aren't, violating our duty of 1.6 to keep things confidential. It's, so if it's not okay for you to do it, it's not okay for them to do it, and they need to know that. They need to be aware of what your ethical duties are so that they can comply. Actually, and I don't have it on these slides, but if you'll find in paragraph C of both rules 5.1 and 5.3, you can't circumvent these rules by having a non-lawyer basically do your dirty work. So if you're not allowed to friend request somebody, because that's what the rules say, you're not allowed to friend request them, that's a communication and that violates the no contact rule. You can't then ask your secretary to go ahead and make this friend request so that you can view the profile. That would not work, and you would be violating rule 5.3 C. So that's something to keep in mind. Don't try to circumvent the rules by asking somebody else to do that for you. So the next set of rules that we're going to talk about will be the unauthorized practice of law. And so how could unauthorized practice of law and social media, how could they intersect? Well, it's pretty easy, because when you're talking on social media and you're interacting, which a lot of sites are very, very interactive, you have immediate responses, so you can go back and forth pretty quickly. There's an air of informality to this. And so all of a sudden you're an Ohio lawyer and you're talking to a person in another state about that a dispute that involves that state's law, and you're giving advice. Well, you are committing the unauthorized practice of law, even though you have sat in your Ohio office the whole time while doing it. And another thing I really want to focus on today is this model rule 5.5b2. So that is when lawyers are holding out to the public that they're admitted to practice law in a jurisdiction where they're actually not licensed. So here's an example of what you can do to overcome any challenge like that. So say you have an attorney that's not licensed in Ohio, but they're joining an Ohio firm. And in Ohio, this attorney could apply to waive into the Ohio bar, and they can apply to practice pending their admission. So while the application is pending, they can practice. But they still want to be on the website. How could you overcome this challenge? Well, you would just put the relevant disclaimer. So you would be disclaiming to the public, okay, this attorney is licensed in, let's just say, Montana, but they're practicing pending admission pursuant to, bar rule 1.19 or whatever the rule is. So you're disclaiming to the public that this attorney is not actually holding out to be an Ohio attorney, even though they have an Ohio phone number, they've got an Ohio address, and they look like they're in Ohio. We're disclaiming to the public, no, they're not. And the bar admissions authorities, they actually are looking. So some of these rules may seem a little far-fetched, but truly they're looking. So keep in mind, when it comes to rule 5.5, so the unauthorized practice of law, there's no jurisdictional limits on your interactions. You don't know necessarily where that person is that you're talking to. So be careful what you say. Be careful providing legal advice to a client in a state where you're not licensed. And that's where we keep the rule 8.5, the choice of law, in mind, because you can subject yourself to states, to discipline in states that you're not even licensed in. And make sure to update your information for the public to see. So don't, if you're practicing pending admission or you're doing something of that nature, don't wait to do it. Make sure that you do it quickly. So the Chapter 7 rules that we're going to talk about here are, these are the rules that you use when you are advertising or marketing, or in some cases, soliciting, but we're not going to get too much into the solicitation of new clients. Nonetheless, Model Rule 7.1 makes sure attorneys know that you should not make false or misleading communications. It should be fairly obvious that you can't lie about your services, but what is not as obvious is the fact that you can make truthful statements that are misleading. So you want to make sure that you do everything in your power to correct any misleading statements. So one way to do this is to make sure that when you are marketing your services that you're talking about verifiable facts. So saying that you're the best lawyer in town is not a verifiable fact. Saying that you were voted to be a super lawyer, that is something that's a verifiable fact. Now, I think there is one jurisdiction where there's a little stickiness with putting that out. I think that's New Jersey, but nonetheless, a lot of jurisdictions, it's going to be fine because that's verifiable. So this is reporting your achievements. Generally okay, but just make sure that it's something that can be substantiated or verified. And so, this is where disclaimers can come into place again. So saying, you want to have a disclaimer that makes sure that the person that's viewing your website or your blog or what have you doesn't have an unjustified expectation that you could get the same results. So an example disclaimer is statements on this website or blog of prior results do not guarantee a similar outcome. So Ohio has an ethics opinion that says as much. So a client says that a lawyer may include a client testimonial. And this is great because then you kind of get around the 1.6 information because that client is, essentially agreeing to waive your duty of confidentiality in a sense, and they're willing to put this client testimonial, giving their name, and giving the facts about you and your representation that would make you a desirable candidate to be, the viewer's next lawyer. But so you can do this so long as it's not false, misleading, or a non-verifiable communication. But they're saying if you have this testimonial, it doesn't say you should have an appropriate disclaimer to avoid unjustified expectations, but you shall have such disclaimer. So the next topic that we're going to get into is, sometimes when you're on social media, a lot of times when you're using social media, your conduct could actually constitute advertising. And that's going to be on somewhat of a case-by-case basis. But I'm going to give you a few examples of a few states, and they've given context as to when certain conduct would be considered advertising. So in New York, there was a female attorney who inquired about whether she could post YouTube videos and whether that would constitute advertising. And the New York State Bar Association said, okay, well, to the extent that these YouTube videos are just providing general information to the public about what being a lawyer in the United States looks like and what kind of work-life balance challenges you have and how you could overcome them, okay, this isn't going to constitute attorney advertising. However, if you include information and news about your specific practice, and that may constitute advertising. So news about her practice for the for the primary purpose of retaining the viewer, then that could constitute advertising. So looking at another example. So a LinkedIn profile that contains only one's education and current and past employment, not going to constitute attorney advertising, at least according to the New York County Lawyers Association. And however, if you are including more descriptive information, such as your areas of practice, your skills, your endorsements, that's going to be considered attorney advertising. And you're going to have to pay attention to New York's Rule 7.1 because there's going to be certain action that you're going to have to take. So California, another example. So when a blog is expressing the attorney's availability for professional employment services, directly through words of invitation or offer to provide legal services, or even implicitly through a description of the type and character of legal services that the attorney is offering, you're looking at attorney advertising. And why does this matter? This matters because you're going to trigger certain requirements. So you're going to trigger requirements such as having to, actually have the disclaimer that this is attorney advertising. And in some jurisdictions, there's actually many more requirements that you have to take in addition to just the disclaimer. The next thing is that you want to watch out saying that you're a specialist. So let's just say that you're practicing, that an area that you practice in is real estate. So to say that you specialize in real estate and you're wanting to say that on social media, LinkedIn or what have you, you've got to be careful, because even though that's your area of practice, and your colleagues may think that you're a specialist or expert, and you very well may be, the rules of professional conduct don't. And so they don't want any lawyer to say that they're a specialist when they haven't actually been properly certified. So to say that I'm just using real estate as an example, to say that you are a specialist in real estate, no, you're just competent to practice in real estate matters. You actually have to be a certified specialist in a lot of jurisdictions say as much, and they're going to have different certification requirements. Ohio just changed its rule a couple of years ago, I think kind of lessened the requirement a tad bit, but nonetheless, there's still some certification requirements. And also make sure that this is one area. I mean, all of these rules vary from jurisdiction to jurisdiction. A lot of the states model almost all rules, even if they have some minor revisions, off of the model rules as promulgated by the American Bar Association. But specifically with advertising, there is a lot of room for variation from jurisdiction to jurisdiction. So especially those of you who are barred in multiple states, really pay attention to the differences. So the model rules at first, when you're reading it, looks like an attorney is permitted to just talk about or to say that they're a specialist in a particular field. But actually, if you keep reading, so this is a comment 9, that to me it looks like, oh, a lawyer is generally permitted to say that they're a specialist in a particular field. But if you actually keep reading the comments, there's comment 11, and comment 11 says, well, yeah, but you actually have to be certified. And then it goes about, the ways that you could be a certified specialist. So the next rule that I want to talk about here is the 8.2. So here's where you have a situation where you feel that you got an unfavorable outcome for your client, and it was because the judge was biased, or there was some sort of issue with a judge. So, and this happens more than you think, an attorney takes to social media and they talk about how terrible the judge is, and that the judge has no integrity and that they're biased. This never ends well for the attorney, so don't do it. That's my best advice. There's not really a workaround for this one, for this challenge. Don't do it. File the grievance, file the complaint. Don't take to social media to complain about a jurist that you find to be unfair. Let me see here. Okay, it looks like I'm missing a slide, but nonetheless, there was a case, a judge out of New Jersey that, so backing up here, I want to also say that judges are not immune from making mistakes on social media. So it's everybody. So if judges are getting in trouble for it, certainly, we can too. So there was a judge out of New Jersey, Gary Wilcox, and he was posting TikTok videos. He posted like 40 TikTok videos. And the TikTok videos were of him lip syncing to to songs he shouldn't have been singing and lip syncing. Very inappropriate. And in a few cases, he was wearing his robe, so that's not a good look. So he, of course, got suspended. I think his suspension from the bench will be lifted next month. But nonetheless, it took off in the media. And as a consequence, I believe it was the Supreme Court justices, there was some committee in New Jersey where they actually implemented social media rules for judges, and made it clear that this type of behavior was not acceptable, that this was demeaning to the judiciary. And so, so for any confusion that Judge Wilcox may have had, they cleared that up for him and for any judges in the future. There's also another judge, and this judge was Judge Mark Cohen out of, I think it was Philadelphia, it was somewhere in Pennsylvania. And he was posting, he was very passionate about the Democratic Party, and he was posting as much on social media, one post after another, about his support of the Democratic Party, even though he was told not to. And he also was suspended for 3 months from sitting on the bench, because judges are not allowed to post, about politics. So my point is that people are watching, and people will certainly turn you in if they find your conduct on social media to be offensive. So please make sure that what you're doing is something that you would be okay with everybody seeing. So no, maybe avoid the explicit TikTok videos. The next rule that we're going to be talking about is misconduct. And this rule basically, it covers everything. So if you are talking about conduct that you think, okay, I can do what I want, I can post what I want, I can say what I want, I'm just venting, I can be as inappropriate as I want, or offensive as I want, this rule is going to get you. This rule is going to be where, even though your conduct might have nothing to do with the practice of law, or nothing to do in your capacity as an attorney, or with regard to your representation of a client, this is the rule that you need to watch out for, because it's very, very easy to say that conduct falls within one of these paragraphs and that you violated 8.4. So I want to focus on paragraphs C and D. And C is really important. You don't want to use social media in a dishonest or deceitful way. And especially when it comes to social media that you're using for a case that's in court, you could be easily found to violate paragraph D, because your conduct could be prejudicial to the administration of justice. So the next case I'm going to talk about, and this is a little bit of an older case, but I think it's relevant to talk about, especially because, social media investigations, they're certainly part of practice now, and so you need to know what you can and can't do. So in this particular case, there's an attorney that was a county prosecutor, and he had been tasked with handling a murder case. And so he was given a certain alibi by the defendant, but he didn't believe it. And so he had listened to a jail call, and he realized that the alibi witness was this defendant's girlfriend, and she believed that he was cheating on her. And so so this attorney could smell some weakness here. And so he goes and he creates a fake Facebook account pretending to be the other woman. And he starts, so he's pretending to be this other woman, and he friend requests the alibi witness, that's the girlfriend of this defendant, and basically confirming that there was some unfaithfulness going on, and and he's all the while trying to get information saying to get this the girlfriend, the alibi witness, to say alibi was made up. I was just doing that to protect him. But now that I know he's a cheater, I'm going to make sure that, you know, that basically the alibi is not going to be, you know, as tight. So he's poking holes into this case. Well, anyways, this attorney goes on medical leave, and another prosecutor has to take the case. Long story short, the other prosecutor figures it out, figures out what happened. It was not a good situation, hit the media. The attorney was fired from the prosecutor's office, and disciplinary proceedings ensued. And so it was found that he actually violated this 8.4 C and D because he was deceitful in his conduct, and you know, it violated D because it was prejudicial to the administration of justice. They had to hire a special prosecutor to come in and handle the case. It delayed the case. I mean, so it was a mess. So anyways, nonetheless, be super careful that you are aware of the ethics rules in the jurisdiction and what they say about, you know, what's permissible investigation and what's not. Using trickery or deceit is usually not going to result in what you want. It's going to result in discipline. So with that being said, this segment of the presentation is over, and if you have any questions, please let me know.
Good morning, everyone. My name is Jen Roach. I'm a partner at Thompson, Hine in the Business Litigation Group, and I'm chair of the firm's, or co-chair of the firm's ethics committee. You get to hear me for an hour, so sorry about that up front, but we're going to spend the first 40 minutes talking about generative AI and legal ethics issues, and the the last 20 minutes we'll talk about an amendment to one of the model rules and the Corporate Transparency Act, which last week had a little twist thrown into the plot for that. So we'll get to that later. Okay, so we have only bits and pieces of information, but what we know for certain is that at some point in the early 21st century, all of mankind was united in celebration. We marveled at our own magnificence as we gave birth to AI. Anybody know what movie that quote is from? Very good, from The Matrix. Excellent. So Captain Morpheus here was explaining to the newly freed Neo that the world that Morpheus once knew was gone, that he must embrace reality, that artificial intelligence has changed everything about human existence. So fast forward 24 years, it's shocking that that movie was 24 years ago, but now we're obviously in the 21st century, and we might feel like AI is changing everything we know it in the legal profession, at least if not in our own personal lives. So lots of efficiencies can be gained through the use of AI and generative AI. We've been using AI for years in discovery to conduct document reviews and litigation and due diligence, to scan contracts and identify key provisions or common contract provisions. That's been going on for quite a while. Generative AI now is drafting correspondence for us, contracts, wills, summaries of documents, summaries of depositions, and helping us generate ideas and test ideas. Firms like ours and others are evaluating and experimenting with AI technologies or developing their own internal platforms. The potentials for using AI in our practices are enormous. At a conference earlier this year, ChatGPT took 53 seconds to draft a complaint in a breach of contract dispute that a retired federal judge called very serviceable, and then 50 seconds to draft a motion to dismiss with accurate citations that the judge reviewed and said was serviceable and credible. At the same time, ChatGPT took 30 seconds to completely make up answers to interrogatories in that same case. So human involvement and review and oversight is certainly necessary to fulfill our ethical obligations, no matter what tool you're using. So what are we talking about in terms of AI and generative AI? There are different definitions, but basically one definition of artificial intelligence is that it's software used to perform tasks or produce output previously thought to require human intelligence. Think Lexis and Westlaw and the search function in your Microsoft Outlook. Today we're going to talk about generative AI or GAI and our ethical obligations when using that tool. So the definition of that in short, well, ChatGPT is one example, so if you've used it, you already know what that's about. But GAI creates content from a set of training data. It can create a text, images, music, videos, code, and more. It learns from and mimics large amounts of data, and it can reuse what it learns to solve new problems. So some GAI tools like ChatGPT are self-learning, where they continue to evolve and develop responses as they receive additional inputs. And if you're using this for legal work, that certainly raises the possibility that a client's information would be stored within the program and revealed in response to future prompts and queries by third parties. So one reason to be really careful about using GAI in the legal practice. So I asked ChatGPT, what does it think about a lawyer's ethical obligations when using generative AI, to see what its response was. You can see this is exactly what I got. Numbers 1 through 8 is what the response was from ChatGPT to my prompt. It did a pretty good job of summarizing our ethical obligations. There's certainly some nuance missing and things like that, but basics are to protect the confidentiality of client data, competence to understand how to use AI and that a human must verify the output, communications, tell clients when you're using AI and how you're using it, and make sure that they're involved in significant decisions in the matter, supervision of non-lawyers, which should also supervision of lawyers here as well, and then compliance, checking court rules and requirements for the use of AI. One thing to note, there's nothing in the professional rules, the rules of professional conduct that prohibits use of machine learning or artificial intelligence, but you have to use the tools competently, ensure that confidentiality is preserved, and review and supervise the work product. And depending on the circumstances, you may need to consult with your clients about using AI in your practice. Amy covered Rule 1.1 a little bit earlier. We're not going to read through it here, but this is where our discussion starts. What level of competence do lawyers have to have regarding GAI? The framework for our discussion is going to come from ABA Formal Opinion 512. It's in your materials. It was issued in July of 2024, and I urge you to read it. It's got a really good in-depth discussion of all of the ethical rules that are implicated by GAI, more than what we have time to cover here today. So what does competence in using GAI look like? Formal Opinion 512 includes the section on competence, and the bottom line is that lawyers need to understand the risks and benefits of using GAI in their practices and have a reasonable understanding of what the tools can do and where they have limitations. You don't need to be an expert in how the technology works, that is clear, to competently use AI in your practice, but you do need to understand what GAI tools are available that are relevant to your practice that you can use to competently represent your clients. So Opinion 512 suggests that to satisfy this obligation of competency, lawyers should consider reading about generative AI tools targeted at the legal profession, attending relevant CLE programs, not this one because I'm not going to go into the technology, and consult with others who are proficient in generative AI. You need to stay informed about the ethical issues and best practices for using GAI in the legal practice, and you need to understand the specific technology that you're using, what it can do, what its limitations are, and the best practices for using that technology in your work. Because these tools are evolving really quickly, it's tough to keep up with everything that's going on and what might be beneficial to your practice. So this is a place where reliance on a third party, an IT expert, a consultant, drawing on the expertise of others can provide you with the competence necessary. You don't have to, learn this all on your own. You can rely on those sorts of perhaps internal sources if you're at a firm, or external sources as well. One other thing to note with respect to Rule 1.1, different lawyers can perform the same task through different means and still comply with Rule 1.1. But the point is you need to know what these tools do so that you can make an informed decision about whether to use them in your practice, how to use them in your practice, and how use of them lines up with your client's objectives and interests. So we mentioned that GAI tools have limitations that lawyers need to be aware of. The biggest one is probably that they produce inaccurate output or they hallucinate. GAI tools are only as good as the underlying data on which they're trained. And if you ask a GAI tool a question, you're going to get an answer. But it may be based on outdated, biased, or limited data. and you're going to get results that are unreliable, incomplete, or potentially discriminatory. So some of these tools, and I'm not picking on ChatGPT, I'm just referencing it most often because it's the one that people are most familiar with and probably use more than others. But ChatGPT is prone to hallucinations. It's getting better, but the possibility is still there for sure. These tools can literally just make things up, like the interrogatory responses that we talked about, or case law. They give you seemingly plausible responses when you read them that actually have no basis in any fact or source. By now, most lawyers have read or heard about other lawyers getting caught using GAI to draft briefs. The most famous example is Mata versus Avianca, a case out of the Southern District of New York from 2023. In this case, the lawyer for the plaintiff, Mr. Schwartz, filed an action in state court in New York. It related to a food cart bumping into somebody's knee as a plane was landing at JFK. It was a personal injury action. The Avianca removed the case to federal court. Mr. Schwartz wasn't admitted in federal court, so he asked one of his partners to appear on the pleadings, file a notice of appearance, and proceed with the action. But Mr. Schwartz continued to perform all of the substantive legal work. I will say, aside from the use of GAI to draft briefs in this case, just reading through this case is sort of an exercise in spotting the ethical issues, and this could certainly be used on a bar exam or an ethics course in law school. There were so many steps along the way that these lawyers could have done things differently that would have changed the outcome. So Mr. Schwartz drafts the brief, Mr. LaDuca files it. They work at the same firm, partners in the same firm, but Mr. Schwartz doesn't practice in federal court, Mr. LaDuca does. The case cites judicial decisions purportedly from the Federal Reporter, Federal Supplement, and Westlaw. Mr. LaDuca later said that he reviewed the brief for grammar and stylistic changes, but he didn't review any of the case law or ask Mr. Schwartz about his research. Avianca files a reply brief on about 2 weeks later and note that they can't locate most of the cases cited and that the cases that they can locate don't stand for the propositions for which they're cited. Mr. LaDuca sees that on his ECF, forwards it immediately to his partner, Mr. Schwartz, doesn't read it, and Mr. Schwartz never withdraws the opposition or has any communications with Mr. LaDuca after receiving the defendant's or the plaintiff's reply brief. So the court then directs Mr. LaDuca to file an affidavit, including copies of the decisions cited in the opposition. There were 9 of them that the court specifically asked to be provided. And the order said that failure to comply will result in dismissal pursuant to 41B. Mr. LaDuca says, okay, great. My partner, Mr. Schwartz, prepared this affidavit. There's some cases attached, but they're excerpts. They're not the whole case, but he goes ahead and files the affidavit anyway. He said he understood from Mr. Schwartz that it was the best that he could do. And in a subsequent affidavit, Mr. Schwartz said he used ChatGPT to supplement his research, that he had conducted his own research, but then admitted that he didn't really have access to Lexis or Westlaw to do the research that he needed. So the court said that this was a misrepresentation. He didn't use ChatGPT to supplement his research. It was the entirety of his research. So that supported a finding of bad faith on Mr. Schwartz's part. Throughout this proceeding, it was pretty remarkable all the different attempts that the court made to get Mr. Schwartz and Mr. LaDuca to acknowledge that they had made this mistake or error. Mr. Schwartz said that he could not fathom that ChatGPT could provide multiple fictitious cases until he read the court's order scheduling a show cause hearing. So this is after like weeks and weeks of this going on. He said in one affidavit that he believed the cases must exist because ChatGPT said they could be found on Lexis and Westlaw, even though he never went and actually checked that they were on Lexis and Westlaw. The court and the opposing party had said that they couldn't find them there. The court throughout, or at the end of this process, starts raising the possibility of Rule 11 sanctions. That's ultimately what happens. They didn't get a large monetary penalty, $5,000. I think probably more of a penalty was the embarrassment that this has generated for these lawyers and their firm, because they're famous now for not a good reason. And they did have to write letters to all of the federal judges whose opinions that they cited, or purported opinions that they cited, that really didn't exist, that ChatGPT had drafted for them. So Rule 11 is certainly a source of sanctions. We just saw that in the Schwartz case. The court there said because they didn't withdraw the brief, and they never attempted to withdraw the brief, and they never advised the court that it couldn't rely on it, that they would be sanctioned under Rule 11b2, which is there on your screen. The Southern District of New York said the submission of fake cases was an unprecedented circumstance, and that the lawyers had abandoned their responsibilities when they submitted the GAI drafted brief and continue to stand by the fake opinion cited in that brief. The court noted that they not only failed to make reasonable inquiry into the cases that they cited, but then they continued to rely on those cases. So again, multiple points here where this situation could have turned out differently. Rule 3.1 is the rule of professional conduct that is corresponding to Rule 11, basically. So although the court's not going to be able to subject the attorney to disciplinary violations in the court action, they certainly can be the subject of separate disciplinary violations by the state bar. Here, 3.1 tracks the language of Rule 11. So I'm not sure if Mr. Schwartz and Mr. DeLuca are in that situation right now, but they certainly could be, because this would be this basis for attorney discipline. As with Rule 3.3, which the Avianca court did cite, cited New York's Rule 3.3, which is very similar to Ohio's, which is what you see on the screen. The court noted that the submission of fake opinions is an abuse of the adversary system. Same thing in Ohio. For a lawyer to knowingly make a false statement of law to a tribunal and fail to correct the false statement of law previously made to the tribunal by the lawyer, it's a violation of Rule 3.3. They also could get in trouble under Rule 8.4, which Amy mentioned earlier, for misconduct. The failure to review the GAI work product to verify the accuracy and the sufficiency of the research and the tasks that GAI performed can lead to violations of all of these rules that we just talked about, including competence for sure, which is what we started off with. The rules don't just apply in court proceedings. So for the non-litigators in the audience, you also need to review and verify facts, contracts that you may have GAI draft, anything like that that you're going to hand over to a client or an opposing party. You still can be subject to violation of these rules if you're relying solely on GAI and not doing your own due diligence, your own review, and your verification of the output. So courts have begun to create new rules, standing orders, or implement new policies that relate to the use of AI in court submissions. Some courts mandate attorney disclosures and verifications. Others just outright prohibit the use of GAI. A lot of this is in response to the Avianca decision that we discussed. One federal judge in Texas has a standing order that states that generative AI is, quote, the product of programming devised by humans who do not swear an attorney's oath. As such, these statements hold no allegiance to any client, rule of law, or the laws and Constitution of the United States, or the truth. Unbound by any sense of duty, honor, or justice, such programs act according to computer code rather than conviction, based on programming rather than principle. So I would not want to be in that judge's court and submit a brief that was based on GAI's research or drafting. If you're a litigator, it's really important to check the local rules and standing orders to determine if you're permitted to use AI or if such use must be disclosed. This on your screen is an order from Judge Boyko, who's in the Northern District of Ohio. It prohibits AI in the preparation of any filing submitted to the court. It excludes legal search engines like Westlaw or internet search engines like Google, but it does make clear that lawyers who violate the rule may face sanctions, including a fine, contempt, or dismissal of the lawsuit. So you would think after Avianca that litigators had learned that you can't rely on ChatGPT to draft briefs for you, and particularly those in New York federal courts, but that apparently didn't happen because in the Second Circuit, a lawyer submitted a reply brief that included fake citations. There are only 2 cases cited. One of them the Second Circuit couldn't find and ordered the lawyer to submit a copy of the decision. The lawyer said that she was unable to furnish a copy of the decision, and she explained that in her research on Lexis and Westlaw, she couldn't locate a case for what she considered to be a really uncontroversial proposition. It was that the minimum wage should be applied to an injured worker lacking prior year income records for a compensation determination. That's what she thought was uncontroversial. She said she couldn't find anything about it. And because she was a subscriber to ChatGPT and she paid a fee, she thought it was a reliable source. She also pointed the court to the fact that it was reliable because it had helped her find some specific type of antique furniture key in her personal life, and so that meant that ChatGPT was reliable. She claimed that also that she didn't really rely on this case, she didn't quote it, and so just citing it was okay. As you can imagine, the Second Circuit did not take kindly to those arguments. They didn't buy them. The court said at the very least, Rule 11 requires the lawyer to read and confirm the existence and validity of the cases on which they rely. They need to confirm that their submissions are accurate, and this lawyer made no inquiry, let alone a reasonable inquiry, into the validity of the arguments she presented, so she violated Rule 11. In this instance, instead of a sanction, the court referred the attorney to the court's grievance panel, noting that technology should never replace the lawyer's most important asset, the exercise of independent legal judgment. So one more case, and there are many, these are just some examples. This comes out of Ohio. This case was getting close to trial. The defendant had submitted a motion for summary judgment. The court said that after learning or being alerted to the fact that there were fake citations in the summary judgment motion by the plaintiff's counsel, the court said, we're too close to trial. I'm not gonna, in a position to separate the wheat from the chaff and just dismiss the summary judgment motion. So if it isn't clear already, using GAI has real implications in your practice, can violate Rule 11, violate ethics rules. ABA Opinion 512 says you can use GAI as a springboard and a foundation for your legal work, but that lawyers can't abdicate their responsibilities by relying solely on GAI to perform tasks that otherwise would call for the exercise of professional judgment. You're responsible for your work product, and you can't leave it to GAI to offer legal advice to your clients, negotiate claims, or prepare pleadings, draft contracts, or other things that require your judgment and participation. All right, so next we'll switch to confidentiality, second rule that's implicated and that ChatGPT correctly identified as a source of ethical obligation for lawyers while using its program. Rule 1.6 provides that you can't reveal information related to the representation of a client without consent. Amy talked about this earlier, so we're not going to go over all of that, but one thing really to note here, especially when you're using GAI, is if you've learned the information in the course of the representation, it relates to the representation, regardless of its source, even if it's publicly available, that's still protected by Rule 1.6. And so if it's publicly available, if it's not publicly available, protected by 1.6, even if it is, but if you've learned it in the course of the representation, you have to consider it as confidential. Similar protections apply for information from former prospective clients under Rules 1.9 and 1.18. And Rule 1.6c, which isn't on the board here, but it does require that lawyers use reasonable efforts to prevent the inadvertent or unauthorized disclosure or unauthorized access to information related to the representation of a client. So the bottom line is when you're using GAI, you need to make sure that you're safeguarding information relating to the representation of your client. I thought this would be illustrated best by an example, a real world example of inadvertent disclosure of confidential information. This was widely reported on in 2023. There were 3 Samsung employees that inadvertently leaked source code, a testing sequence, and then some internal company discussions to OpenAI, which is the company behind ChatGPT. They'd been warned not to do this, but then within a couple weeks just went ahead and did it anyway. In one instance, a Samsung employee found a bug in the source code of a download program for a semiconductor plant measurement database and asked ChatGPT for a solution to that bug. In the second, the employee recorded an internal company meeting on his smartphone, transcribed it using a speech recognition application, and then fed it to ChatGPT to generate meeting minutes. Both of these acts gave OpenAI and potentially Samsung's competitors insights into Samsung's technology and internal operations. If a user used the correct prompts on ChatGPT, they could get access to this information that the Samsung engineers input into ChatGPT. So what you tell these tools, if they're external, will end up on external servers. That means once you let the cat out of the bag, it's out there, it's in the public domain. There's no way to retrieve that data. And the potential certainly exists that users can access this information through prompts submitted to ChatGPT. So, you know, this may not be the case with all GAI platforms, like those that are internal to a firm, because different GAI tools have different functionality to ensure that information is protected from disclosure or access. That's part of what you're going to need to analyze when you're looking at what tool you're using, what you're using it for, what its functionality is, and whether you might need to obtain client consent. So the key takeaway here is you need to understand what happens to the information you put into GAI and what information you're getting out from a GAI tool and what protections are in place to evaluate that risk. Some of the things that you can do are read the terms and conditions of use, the privacy policy, or related contractual terms of the GAI tool that you plan to use. Consult with a colleague, your IT professional, or some external expert to help you understand the tool and the parameters of the tool, how it uses information. Confidentiality concerns can certainly be mitigated by using an in-house GAI tool or a captive GAI tool, meaning that it's only accessible to the lawyers in your firm or only accessible to the employees of your corporation. But there's a risk that information related to one client matter could be disclosed improperly. That still remains. Both of these opinions cited here are the Pennsylvania and Florida State Bar Association opinions deal with this topic, and they note that even if GAI tools are captive, there's a risk that information from one representation could be used to inform work on another representation, enabling a lawyer to inadvertently use one client's information on another client's matter, not even understanding that you might be revealing confidential information or reviewing confidential information. This is of particular concern where there might be ethical screens in place that prevent sharing of information, and it could easily be inadvertently disclosed just through a prompt, even if the system is captive. All right, communication is rule 1.4. Next rule that we'll talk about that's implicated in the use of GAI tools. Rule 1.4A2 requires a lawyer to reasonably consult with the client about the means by which the client's objectives are to be accomplished. And under Rule 1.4B, consent to use GAI, if it's required, it must be informed. So that's one thing to note here. You'll need to explain to your client how the tool is going to be used, the extent of the risk that later users of the GAI tool have access to information related to the representation, the kind of information that's going to be disclosed, and the benefits of using the GAI tool for the representation. So all of that's going to be relevant when you're having these conversations with your client if you're going to be including client information in a GAI tool. Opinion 512 says that to obtain informed consent, merely adding a boilerplate provision to an engagement letter purporting to authorize the use of GAI is not sufficient. And the ABA opinion, as well as the Florida and Pennsylvania bar opinions and others, are really clear that a client's informed consent is required before using a third-party GAI program if using such tool would involve the disclosure of confidential information. So even if informed consent is not required under Rule 1.4, you are going to have to consult with your client about the means by which the objectives of the representation are to be accomplished, and this can include talking about how GAI is going to be used. This is a fact-intensive analysis, and we can't really cover all the permutations here today in terms of whether this conversation with your client is going to be required. One example, if you're using GAI tools to just generate ideas, you're not inputting any client information into the tool, informed consent is likely not going to be necessary, perhaps maybe not even disclosure. One thing to check on for sure, Amy mentioned guidelines earlier. If the client's engagement letter or outside counsel guidelines require you to disclose if GAI tools are being used, that's obviously something that you need to consider and comply with if you're going to be using those tools. Other circumstances that might require disclosure to a client but may not rise to the level of getting informed consent are if a GAI tool is going to influence your advice in some way. If the type of tool you're using or how you're using it or how important it is to the representation, like that may also require some disclosure. If the tool is relevant to the reasonableness or the basis for your fee, you may also need to disclose that to the client. So in working through this analysis, keep in mind that the scope of the representation, the client's needs and expectations and goals all figure into having this conversation with them about use of GAI and whether it's appropriate for your representation. Last thing to note, supervisory response, or sorry, not the last thing, one of the last things, supervisory responsibilities. Amy talked about this a little bit earlier, but rules of professional conduct 5.1 and 5.3 both set forth ethical duties of lawyers charged with managerial and supervisory responsibilities with respect to the firm, subordinate lawyers at the firm, non-lawyers, and third parties like vendors. This also applies to lawyers in in-house positions. With respect to GAI, ABA Opinion 512 notes that there are several ways that managerial lawyers can create effective measures to achieve compliance with the rules of professional conduct. The first is including clear policies on the use of AI that spell out when it can be used and under what conditions and what AI tools are permitted to be used. Another is training on the capabilities and limitations of AI tools and the ethical responsibilities surrounding the use of those tools. Also, training on best practices for data security and handling confidential information is one of the things that Opinion 512 cites in terms of meeting this obligation that you have under Rules 5.1 and 5.3. The supervisory responsibilities that you have under these rules extend to members of your firm, but also outsource legal and non-legal services to third parties. So these same concepts are going to apply to the GAI providers and tools as well. Last, talk about unauthorized practice of law and GAI. Rule 5.5, and there's different variations in every state, but basically says that a lawyer can't practice law in a jurisdiction without a license or other authorization, and that you can't assist another in doing so. The basic question to this is, what is the practice of law, and is using GAI the practice of law? It's likely to come up in the future, hasn't come up really up to this point in any ethics opinions or case law. But if GAI use is the practice of law, if you're using it to draft a pleading or draft a contract, it seems like it would be. If that's the case, non-lawyers relying on AI to advise third parties might be committing or would be committing unauthorized practice of law. But more important for this group is that if a lawyer relies on GAI and you're not involved sufficiently in the process in working through the prompts and review of the information, and you've basically abdicated your supervisory responsibilities, that could create a situation where the lawyer assisted another in the unauthorized practice of law. So there are certainly core activities that you would identify with the meaning of the practice of law, appearing in court, drafting documents that are going to impact people's rights like deeds or wills or contracts, and providing legal advice. GAI can do all of those things, so that's really what the issue is here. There's been a lot of litigation in many states over software like LegalZoom and the disclaimers that they have to include and that they have to publish in order to avoid UPL and what they can and can't do. But what we haven't seen yet are any lawsuits or ethics opinions or disciplinary actions dealing with a lawyer who uses GAI to draft a pleading or document when they're having a paralegal or another non-lawyer prompt the tool to actually create the document. So to be determined here how this is going to play out. One final thought, it's important to note that we're still in the early days of use of GAI in the legal profession, and these ethical concerns are not exhaustive. They're certainly not static. They're going to evolve right along with the technology, so stay tuned. Next, we're going to talk about, shift gears and talk about the amended Model Rule 1.16 and your duty to inquire into the facts and circumstances of a representation. I originally planned this presentation thinking that it would be great timing. The Corporate Transparency Act has a January 1st, 2025 deadline for non-exempt entities to submit beneficial ownership information and reports. This would be a great reminder for lawyers that are working on those matters that you need to conduct some due diligence if you're going to be involved in filing any of those reports. But things clearly did not go to plan because last week the Eastern District of Texas issued a nationwide preliminary injunction against enforcement of the CTA. said that the CTA is likely unconstitutional, and the CTA is enjoined, and the compliance deadline is stayed. It can't be enforced, and reporting companies need not comply with the beneficial ownership reporting deadline of January 1st. So despite my best laid plans to talk about the CTA, they've sort of been scuttled by the decision last week. FinCEN, who's responsible and you'd have to submit those reports to, subsequently issued a statement saying that in light of this recent federal court decision, companies aren't required to file beneficial ownership information, and they're not subject to liability if they fail to do so while the order remains in force. You can obviously continue to voluntarily submit these reports. But so CTA is kind of off the table for now, so we're not going to spend our time talking about it, other than to say that a lot of the due diligence obligations that we're going to talk about under amended Rule 1.16 would equally apply if you're working on CTA matters and you're going to be responsible for preparing and filing any of those reports in the future. So both the ABA's amendment to Rule 1.16 and the CTA were designed to address illicit finance, which means things like money laundering and terrorist financing. They both involve an element of due diligence by the lawyer, although the CTA was certainly not intended with that target, with lawyers as a target in mind. The 2023 amendment to Rule 1.16 adds two provisions. The first is that a lawyer shall inquire into and assess the facts and circumstances of each representation to determine whether the lawyer may accept or continue the representation. And second, that a lawyer shall not represent a client or where representation has commenced shall withdraw from the representation if the client or prospective client seeks to use or persists in using the lawyer's services to commit or further a crime or fraud. Now, the CTA, we talked about the reporting requirements. You may have to file those in the future, maybe, but not today for sure. The ABA points to the prior version of 1.16 and some ethics opinions to say that, hey, lawyers already had this obligation of due diligence. This amendment, though, really seems to be in response to pressure from Congress that the ABA either amend Rule 1.16 or risk increased oversight by Congress. The ABA's treasurer and representative to the Treasury Department said at a House of Delegates meeting prior to the vote on this amendment that, quote, Treasury informed me last Friday that the failures of the ABA to adopt this amendment will cause Treasury to explore every means available in its regulatory toolkit to impose anti-money laundering regulations on the legal profession. So despite the fact that the ABA has taken the position that these obligations and this duty, the due diligence duty were already included in its existing rules, and they've pointed to several ethics opinions that talk about those rules, they felt that it was necessary to amend Rule 1.16 to be explicit in what's required of a lawyer and their due diligence obligations. So what changes with this amended rule? ABA issued a formal opinion in August of 2024 discussing that question. It's opinion 513. 513 does focus on the amendments, but it also notes that the amendment doesn't really add any new obligations. It just clarifies existing obligations. And it's true that many of the rules of professional conduct and ethics opinions can be read together to imply a duty to inquire and assess the facts and circumstances of a representation. That includes everything from conflicts under Rule 1.7 to the duty of diligence 1.3, communication 1.4, and honesty and integrity under Rule 8.4. But the opinion 513 says that really what was intended was to make these obligations explicit so that they can be found in one place. You don't have to search around through multiple rules and ethics opinions. You may be sitting there thinking, why does this matter? The state of Ohio or the state where I'm licensed hasn't adopted the amended Rule 1.16 yet. That's true, but many states do adopt, sometimes just verbatim, the model rules and amendments to the model rules. So it could be coming to a state near you. Also because they're not new obligations, as opinion 513 notes, the model rule 1.16 can really just serve as persuasive authority for the duty of diligence that lawyers already have and already have to undertake under existing rules. At the very least, reading opinion 513 to lay out the rules and ethics opinions that do exist where this duty to inquire and assess it can already be found is something else that the ABA pointed to. So what does an inquiry that complies with Rule 1.16 look like? Opinion 513 makes clear that the inquiry a lawyer conducts shall be appropriate for the circumstances. There is no one-size-fits-all rule or approach for client due diligence. The scope and extent of the inquiry varies depending on the circumstances, and it's going to also vary with each client. And they are very, they really focus on the fact that the reasonableness and proportionality are key concepts in the risk-based approach. The duty to inquire is both at the outset of the representation and also continues through the representation under Rule 1.16, although it's not clear what exactly specific change to the rules or to the facts or circumstances might trigger such an obligation. This is also something that has to be assessed on a case-by-case basis and is going to depend on the client and the circumstances. Comment 2 to Rule 1.16 identifies 5 non-exclusive factors that a lawyer must consider when assessing the risk posed by accepting or continuing a representation. And again, that risk is that the lawyer's services might be used to further criminal or fraudulent conduct. So that's what these factors are tailored to. The first is identity of the client. If it's an entity, who are its beneficial owners? What is its ownership structure? Second, your experience and familiarity with the client. If it's a client that you've done business with for 20 years, the risk is pretty low that it's going to that your representation is going to be used to further fraudulent or criminal conduct. The nature of the requested legal services. What's the scope of the representation? What are you being asked to do? There are certain types of matters like drafting a will that's going to pose a really low risk of criminal or fraudulent conduct, but something like a cash-based real estate transaction might pose a higher risk of things like money laundering. So taking a look at the scope of the representation, what you're being asked to do. The relevant jurisdictions to the representation, what countries are you dealing with here? Also something to come into play, and the citizens of the countries that you're going to be dealing with in the course of your representation. Finally, identities of those depositing money into or receiving funds from trust accounts is something that also should be considered when you're assessing or conducting this risk assessment. So what does this look like in practice? Before beginning most representations, the inquiry is really not going to go beyond what you normally would do in opening any matter. A conflict check, checking watch list, some initial financial due diligence, and a review of the nature of the representation. In most instances, that's going to be sufficient, and you can end your inquiry there, no risk, so go ahead and take on the matter. Like we talked about, there are specific matters like perhaps drafting a will, defending a personal injury lawsuit, really low risk that that representation will result in the lawyer assisting in a crime or fraud. No further due diligence is going to be required. Transactional matters, just by their nature, have a greater risk, but that can certainly be mitigated by factors like who is the prospective client? Is this a client that you've done, oops, sorry. Is this a client that you've done business with for a long time? Do you have a prior relationship with the client? What was your referral source? How did the work come to you? And other circumstances surrounding the representation. Are you going to be? Is the matter going to involve the use of recognized legitimate financial institutions? Another big factor in this risk assessment. If there's a heightened risk because of some red flags, like the prospective client contacted you directly, they found you on the internet. No good is likely to ever come from that. If there's no referral from another lawyer that you've worked with and they just reached out to you because they saw you online, that definitely would raise a red flag. The transaction is going to involve cash payments. The client originates in a country where there's a high risk of corruption. All of those things can be red flags that would should alert you, and certainly would alert a conflicts analyst about the need to make further inquiry into the situation and to get a better understanding of the facts and circumstances of that representation. If you decide after a reasonable inquiry that representation is unlikely to result in you being involved in committing a crime or fraud or assisting the client to, you can certainly undertake that representation, no issues. That's going to be the case the vast majority of the time. If there are still some unresolved questions, it's your obligation to then go ahead and make some additional inquiry. It can't be a perfunctory review. It has to be reasonable. It doesn't mean you have to overturn every stone and track down every last fact, But if there are still some unresolved questions after that first analysis, the conflict analysis, the financial due diligence that we talked about, you need to ask questions to get some more information. If the client's cooperating, providing you with the information, and you can still conclude that, yeah, maybe there's still some things that I don't know, or some questions that I would like to have answered, but it seems like it's really unlikely that this is going to result in any assistance with a criminal or fraudulent conduct, then you can undertake the representation. So the opinion 513 has a couple of examples in it of hypothetical foreign investors and how you would walk through this process. It's probably easier to see when it's actually applied to a set of facts. So the first one, an investor based outside the US contacts an established real estate lawyer seeking representation regarding the proposed purchase of an office building in the lawyer's city. The lawyer hasn't represented the investor previously, but was referred to the lawyer, but the client was referred to the lawyer by a real estate lawyer in another state who represented that investor in several similar purchases. So here's our example. If this comes in the door, what should you do? Check conflicts, confirm billing arrangements, evaluate the client's ability to pay. These are all sort of the basic steps that we can take to satisfy our duty to inquire. If an entity is going to be formed as part of this transaction, ask about the investor as well. Ask questions about the entity, the beneficial ownership, the structure of the contemplated transaction. Here, if you did all of that, you would learn that the investor wants to form an LLC to buy the property. He's going to be the sole member. The entity will be a client, and he's going to finance a transaction with loan from a local bank. That the client resides in a country with a low score on the Corruption Perceptions Index. Here, great, perfect. Everything that you need to say we can take this matter on, no risk. Although the transaction could be considered somewhat risky or higher risk than our personal injury defense relatively, the client certainly is not here. So facts change, circumstances change. This happens all the time in matters. And this is part of what Rule 1.16 highlights as our ongoing duty to inquire into the facts and circumstances and undertake that assessment to see what our services are going to be used for and if they could be used for any sort of criminal or fraudulent conduct. Here, it's a month after you started working on the matter, the client contacts you about another similar building for sale in your city that he wants to buy instead. So the scope of the target building has changed. The new building's available at a good price, but the client tells you that the transaction must close quickly, really fast. The client wants to buy the building using funds transferred from an account in a bank in a country of his residence. So a non-US bank has to happen quickly in a new building. So those are the new facts that we have to work with. Not all of these changes are going to prompt an additional inquiry. Just a change in the target or the building that the investor wants to be acquired is really not something that's going to require you to do any more due diligence. But the change in how the transaction is funded and the timing of the transaction should give you pause, and according to opinion 513, would trigger an obligation to conduct an additional inquiry because cash transactions may indicate a risk of money laundering, and accelerated deadlines, often though they're legitimate for sure, but a nefarious client could use time pressure to rush your work and complete their misconduct before anyone has time to even realize it. So these would be things that the ABA would say that your antenna should be up, and you may need to ask some additional questions if this happens in the course of your representation. So if you ask those, let's go to this slide. So you ask those questions. Here, you use the same matter that you would in assessing the matter, the same standards as you would in assessing the matter at intake as you would during the course of the representation. If you ask those questions with respect to the change that we just talked about in the transaction, you learn that the investor wants to change the scope, change the target to a new building that's going to be in an attractive area for the investor. He knows that there is a competing investor. The client wants to avoid a bidding war. That's why he wants to pay cash. And the funds are going to be transferred from a well-known bank in his country to an escrow account at a local bank set up by the seller. So these facts could all cause a reasonable lawyer to conclude, yep, there's no risk here, very minimal risk that our services are going to be used to further fraudulent or criminal conduct. You can see, though, how different facts might change that conclusion, which is why the duty to inquire is triggered. For example, if the client wants to transfer the cash to an account controlled by the lawyer, set up an escrow account at the law firm, this additional inquiry would be needed as to the source of the funds and what else is going on in that transaction. Model Rule 1.16 and the Opinion 513 make it clear that you have a duty to inquire at the initial stage of the representation and throughout, and to continue to assess the risk your services will be used to further criminal or fraudulent conduct. One thing that's important to note, and I just looked at this recently because there wasn't actually a very clear rule in Ohio. There is an ethics opinion, but it's kind of, it made me stop and think that Congress may have been onto something here, the Treasury Department, when they were pushing the ABA to modify this rule, because it wasn't really in black and white in the Ohio rules. But if you know that your services may be used to commit a crime or fraud, fraud or crime, you have to withdraw. There's no rule in Ohio that says that. There is an ethics opinion that discusses that, but this amendment to Rule 1.16 is what's making that clear, and likely why they did it, also because of the pressure from the Treasury Department, apparently. These duties that we talked about are likely to be implied from other rules or ethics opinions, even if your state hasn't adopted Rule 1.16 or doesn't ever adopt the amendment to Rule 1.16. So you should be aware of them and continue to undertake an inquiry and assessment of the risk that your services would be used in ways that are prohibited by the rules.
Okay, everybody, welcome back. For the last part of today's presentation, I'm going to try and highlight, in the amount of time we have left, a few things that have developed in the biennium since most of you last had to take your ethics classes. Over that time, the ABA has issued a few opinions that are interesting, and more importantly, a lot of lawyers have made missteps that got them into ethical trouble that we can talk about. The last part's going to be a little less studied and informative than what you may have gotten from Jen and Amy, but it might be a little bit of fun and worth the wait. So, for our first items, let's see. On recent ethical news, let's start with some of the new opinions from our friends at the ABA. First is Opinion 508 that discusses the proper and improper ways to prepare a witness, usually your client, for testimony. The ABA says that you can properly remind a witness that he or she will be under oath, emphasize the importance of telling the truth, explain that telling the truth can include the truthful answer, "I don't recall," explain case strategy and procedure, including the nature of testimonial process or the purpose of the deposition. You can suggest appropriate attire, demeanor, and decorum. You can provide context for a witness's testimony, inquire into a witness's probable testimony and recollection, explore a witness's version of events in light of testimony that they expect to be presented. Excuse me 1 second. I have a binder problem that can be addressed. Thank you. There we go. Sorry. Review evidence and documents with the witness, including to refresh their recollection, identify lines of questioning and possible cross-examination, suggest word choices that might be employed to make a witness's meaning clear, advise a witness not to answer a question until it has been completely asked, emphasize the importance of remaining calm and not arguing with the questioner, advise them to only testify about what they're sure about, not to guess or speculate, and encourage focusing on answering only the question asked and avoiding any volunteering of information. So these are all good things and familiar to most of us that are involved in litigation. In fact, it's a very good list of what any good lawyer does in preparing a witness for testimony. So what does the ABA say we should not do? The opinion divides improper witness preparation or representation into two categories: pre-testimony preparation and representation during testimony. Regarding preparation, the opinion focuses on Rule 3.3 4B, which says that a lawyer may not counsel or assist a witness to testify falsely or often offer an inducement to a witness that is prohibited by law. Examples of misconduct the opinion offers include telling a witness to downplay facts, like the number of times a witness and lawyer met to prepare, encouraging a client to misrepresent facts about the case in order to enhance their claim or defense. Other representative examples of unacceptable witness coaching include over-preparation that programs a witness to testify in a specific way, knowingly violating sequestration orders, and encouraging a witness to present fabricated testimony. The other category the ABA talked about has to do with representation during the witness's testimony. Here again, the ABA tells us that we may not do things that are designed to change the substance of a witness's testimony. Some of the concrete examples the opinion gives of prohibited behavior seem almost comical, like winking at the witness, kicking him under the table, or passing notes. It also criticizes the frequent problem of speaking objections. This, of course, is a hard line to draw, given the frequency of opponents asking intentionally improper questions, but there's now some authority that says it can be an ethical violation, so be careful. The opinion also focuses on the problems associated with the now frequent situations of remote testimony. It notes that there have been known examples of improper coaching in remote proceedings where a lawyer and his clients may be the only people in the room and only the witness can be seen by the other participants. The opinion also notes that these sessions present ample opportunity for improper coaching conduct, including texting answers to witnesses and other signaling off camera that can't be easily detected. The opinion points out that any of this conduct violates specific ethical prohibitions, so don't text your client when he's testifying. The opinion point, The opinion points out that these are violations of misconduct because not only does it violate Rule 5.3, but also violates Rule 8.4, which says that it's professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Overtly attempting to manipulate testimony in progress in most situations constitutes at least conduct prejudicial to the administration of justice, according to the ABA. Likewise, many courts have rules or orders restricting speaking objections or instructions not to answer. Violations of these rules would likely constitute a knowing disobedience of the rules of a tribunal, which is a direct violation of Rule 3.4C. So the ABA says, don't do that. Again, most of the do's and don'ts here are things that we all do and see all the time. With an ABA opinion on it now, it may be that an ethical aspects of it are more common in the motion practice we'll see after these depositions. So what else did the ABA tell us of import since our last session in 2022? Another important pronouncement was found in Formal Opinion 510, which dealt with the imputation of conflicts of interest. In this opinion, the ABA is addressing a common problem in law firms, which is avoiding disqualification based on one of our lawyers talking to a potential client about matters that, unbeknownst to that lawyer, the firm is or will be on the other side of. The problem emanates from Rule 1.18, which addresses duties to prospective clients. Subsection B says that a lawyer who has learned information from a prospective client shall not use or reveal that information. And subsection C says that a lawyer can't represent another client with interests materially adverse to the prospective client in the same or substantially related matter if the lawyer received information from that client that could be significantly harmful to the prospective client. And most significant, it says that if the lawyer is disqualified from representation on those based on those discussions, then no one in the lawyer's firm can do so either. In other words, the lawyer's conflict is imputed to the whole firm. That said, the rule has exceptions. Subsection D says that representation by others is permissible if, one, both clients waive the conflict, and two, if the lawyer who received the information took reasonable measures to avoid getting more disqualifying information than was reasonably necessary to determine whether to represent the prospective client. It also says that to use the exception, the disqualified lawyer must be timely screened from the matter and doesn't get part of the fee, and written notice is promptly given to the prospective client. So the main question which the ABA here clarified was, what are the reasonable steps under subsection D2 necessary to avoid imputing the lawyer's conflict of interest to the firm? First, if you want to minimize the risk of law firm disqualification, you should only obtain information that's reasonably necessary to determine whether you can actually do the work, like finding out the parties for conflict checking, ascertaining the nature of the dispute or matter to make sure that you or somebody in your firm has the expertise to handle it, or three, finding out whether the client in this situation are matters that are things that you're willing to take on. The opinion suggests that a good practice is to warn the prospective client to only provide the information you actually request. It also suggested that you could condition your consultation with the prospective client on their agreement that no information disclosed during your consultation will prohibit you from representing a different client in that matter. I think that suggestion may be of some dubious value, and I'm not sure how many sophisticated clients would agree, but there we are. The ABA says it's okay. Most significant here is the opinion's tagline. If the lawyer learns disqualifying information and has failed to take reasonable measures to avoid receiving more disqualifying information than reasonably necessary for these purposes, and no representation ensues, the lawyer's conflict will be imputed to the lawyer's firm. That, of course, is not the result we want. So whenever you're talking to prospective clients, we want you to be careful about how much information you get and caution them not to give you more than you need. Okay, enough with the ABA already. Let's talk about some things that have happened recently in ethics world. I'm going to move kind of rapid fire through these, and if any of them pique your curiosity, feel free to ask questions now or at the end or next year if you want, or 2 years, whatever. I want to start with a series of decisions out of North Carolina where at least 3 lawyers were subject to public reprimand because they were victimized by scams in closing deals. In each case, members of the lawyer's staff wired out sellers' funds to fraudulent recipients. Usually, as we often see, there had been an email changing the recipient account, and no one had verified that change verbally. In the reprimands, the bar identified violations based on Rule 5.3. 5.3 addresses our obligations in managing non-lawyers that work with us. It has several parts. First, it requires lawyers with managerial authority at a firm or organization to make reasonable efforts to ensure that there are measures in place, policies, assuring that the non-lawyer's conduct is compatible with our professional obligations. It also requires lawyers directly supervising non-lawyers to make reasonable efforts to ensure that the supervised non-lawyer's conduct is compatible with our professional obligations. And most significant, it says that lawyers with supervisory authority are responsible, ethically responsible, for any conduct by the non-lawyer that would violate the rules if engaged in by a lawyer. If the lawyer orders or ratifies the conduct involved, or the lawyer has managerial or direct supervisory authority, knows of the conduct, and fails to take available, effective remedial action. We had a case several years ago where the general counsel of our opponent had an issue because his paralegal initiated contact with our client and impersonated someone else in doing so. If the GC had made that call instead of her, he would have violated the rule against contacting represented parties, and it would have violated the rule against being fraudulent. Among other issues, when he found out about it, he not only failed to take remedial steps, he ratified her conduct by forwarding the information to their litigation counsel for use in the case. He got in very hot water with the Attorney Grievance Board, spent a lot of time and money trying to get out of it, and I think hopefully regretted it. But it's a lesson. We have to be careful and monitor what people working for us are doing. Back to North Carolina, the board there also pointed to Rule 1.15. Rule 1.15 requires safekeeping of client funds. In North Carolina, their version of 1.15 is specific in saying that reasonable security requires verifying disbursement changes in wiring instructions. But even without that rule, there would still be an ethical violation. There or here in Ohio or anywhere else in the country, attorneys are also subject to Rule 1.1, which Amy discussed earlier. It's the first rule in the book, and it says that competent representation requires the skill, thoroughness, and preparation reasonably necessary for the representation. And the comments now make clear that competence means lawyers must keep abreast of changes in the practice of law, including the risks associated with relevant technology. The use of wire technology is now intrinsic to many of our practices, and today there are significant risks associated with using that technology. Just last month, one of our lawyers was involved in a transaction where someone else sent a wire of over $8 million to the wrong party because they got fraudulent wire instructions. Again, that was not us, just to be clear. I'm confident that besides a large malpractice problem, any law firm that loses client money because it fails to properly vet and execute a wire is also now going to face ethical problems. Okay, let's move to a few quick notes about the practice as it involves practice by non-lawyers. I'm sure you all know the rules of professional responsibility make it a violation for anyone not licensed as a lawyer to practice law. Over the last few years, we've seen several states loosen that rule in limited circumstances, primarily aimed at assisting underserved populations. A new rule in Texas will allow paralegals to provide some legal services to low-income individuals, including services for family law, estate planning and probate law, and consumer debt law. This is intended to help close the justice gap and address unmet civil legal needs. Here, Texas is joining several other states, including Colorado, Oregon, Arizona, and Minnesota. In a very different kind of initiative, Washington State is considering a pilot program allowing non-lawyer entities, online places, to provide certain legal services. These are primarily online services by companies owned by non-lawyers, and they are putting this pilot program in place to see how it works and if it will harm clients. It's facing stiff opposition, but it looks like it's going to be put in place. Meanwhile, North Carolina is not tolerating any such programs and has been sued by an online company and 2 paralegals who are seeking to enjoin enforcement of the rule that prohibits the unauthorized practice. An injunction against that same kind of rule was entered in New York not long ago. That's up on appeal. In most of these cases, the opponents are invoking the First Amendment and arguing that their services narrow the access to justice gap for low-income individuals. In a similar case, the South Carolina Supreme Court has ruled the state's NAACP branch can train volunteers who are not lawyers to give limited legal service to tenants facing eviction. In many of these cases, the issue also involves the rules that prohibit sharing legal fees with non-lawyers, which are read to prohibit any entity owned even partially by non-lawyers to render legal services. That rule has been abolished in many places, notably Australia and Great Britain, and non-lawyer ownership of law firms is permitted in different forms in New Mexico and the District of Columbia. This is a very complicated issue that's being hotly debated around the country and other parts of the world, and it's going to be interesting to see how it plays out. Right now, none of that in Ohio, but the time may be coming. Okay, here's 2 odd ethical stories involving ghostwriting. Did you ever want to copy someone else's brief because it was so good and file it as your own? Well, don't. A few months ago, Winston & Strawn got sued by a small firm representing a co-defendant in an intellectual property suit, accusing them of copyright infringement for allegedly copying that firm's brief in a companion patent case in the Eastern District of Texas. The small firm filed a motion to dismiss on behalf of its client, and the next day, Winston's lawyers submitted a motion on behalf of their client. According to the suit filed against them, there were numerous passages in Winston's brief that were close to word for word from the brief filed by the plaintiff firm. The small firm promptly copyrighted its motion and then sent a letter to Winston saying that your brief does not constitute fair use, a term that IP lawyers understand. The suit settled shortly after that. I don't have any idea what the terms were, but it got a lot of press attention. The second story here is a weird one where a California bar official was found to have violated conflict rules by ghostwriting reports of investigations. These cases involve matters where the bar's counsel had a conflict and therefore they couldn't handle the investigation. His assistant was supposed to refer those complaints to outside investigators for review to avoid those conflicts of interest. He did retain outside investigators, but then he ghostwrote some of their reports for which he was reprimanded. So why are we talking about ghostwriting in an ethics seminar? Because there's a good argument that wholesale copying a brief and signing it yourself misleads courts, clients, and other readers about what you did and didn't do. In other words, you're making a misrepresentation which violates Rule 8.4's prohibition against dishonesty. And there are, in fact, several decisions out of federal court finding violations of Rule 11 when a pro se party files a brief that's been ghostwritten by a lawyer. They find violation because it misrepresents a fact, which is who actually wrote it. The other problem, of course, is when a lawyer copies a brief wholesale and then bills a client a lot of hours for supposedly researching and writing it. Again, that's fraud. A while ago in DC, a lawyer was disbarred for a series of misdeeds that included filing a brief that was virtually identical to one filed by a co-defendant and then overbilling for the work. Making up time is dishonest. Dishonesty is a no-no. We don't do that. Okay, next up, fiduciary duty. This is an interesting case out of New York with a now former partner at Crowell & Mooring. He was suspended from practicing law based on a finding that he maintained his own personal practice while working at the firm and failed to disclose it to the firm. The court said that the partner secretly performed legal work for non-Crowell clients and also personally billed Crowell clients for work he solely did, outside of Crowell's usual billing structure. He was caught when he sent a bill to a client for the same work that Crowell sent a bill for, which in retrospect was not very smart. Crowell filed a disciplinary complaint against him in both New York and California, where he resided, and the former partner admitted that he engaged in conduct involving dishonesty, fraud, and deceit in violation of the professional rules, which resulted in his long suspension. I'd note here that there are many decisions finding that knowing breaches of fiduciary duty to one's firm is an ethical violation that can warrant discipline. Okay, speaking of lawyers in New York, I want to spend a few minutes of reflection on the ethical dangers of working for clients that take extreme positions and want their lawyers to be very aggressive asserting those positions. These are all real headlines, by the way. This may look familiar to some of you because I used it in this year's office training. I couldn't resist using it again. I love this picture because it reminds me of OJ. And for those of you that don't get that reference, I'm happy to explain offline. Anyway, whatever you think about the president-elect or his policies, there seems to be little debate that being his lawyer came with some real ethical and financial risks. The former Department of Justice Attorney Jeffrey Clark was charged with violating ethical rules relating to his actions after the 2020 election. The DC Ethics Committee found that he should be suspended from the practice for 2 years. He was also criminally charged in Georgia. Sidney Powell, who filed a number of the election contest cases, was sanctioned in Michigan. Then she was indicted and pled guilty to criminal charges in Georgia. She was charged with disciplinary violations in Texas, where she's licensed based on that guilty plea. But lo and behold, a Texas judge dismissed the case but she still faces several defamation lawsuits and a federal investigation into her organization's fundraising. In February, the U.S. Supreme Court rejected appeals by Powell and her co-counsel Lynn Wood to overturn the sanctions issued against them for their work on the lawsuits against the city of Detroit following the 2020 election. Powell, Wood, and others who filed the cases were ordered to pay substantial monetary sanctions over what the judge called a historic and profound abuse of the courts. And while Ms. Powell escaped ethical sanctions, the lawyer defending her did not. He's now facing disciplinary charges in DC over the election lawsuit and appeals he filed contesting the election. And then, of course, there's Rudy Giuliani. He isn't just sanctioned, he's been permanently disbarred in New York and the District of Columbia. He's also been criminally charged in Georgia and Arizona for his role in the post-election antics. He's been sued for defamation and was ordered to pay $148 million to election workers, resulting in him declaring bankruptcy. And let's not forget the original member of this group, Michael Cohen, who not only lost his license, he spent 3 years in jail for election violations related to the Stormy Daniels scandal. In one article I read, there are at least 15 lawyers who have faced criminal, ethical, and financial consequences for their work on the Trump election cases. And the list of trouble for lawyers isn't just limited to election challenges. A DC lawyer and Republican operative pleaded guilty to telecommunications fraud here in Ohio after organizing a campaign of robocalls that told people their personal information would be collected and used by the police and debt collectors if they voted by mails. That conviction resulted in his permanent disbarment. In the interest of balance, I'll also note that in July, ethics charges were filed against a federal prosecutor alleging she used deceptively edited videos as evidence in criminal cases against January 6th protesters. The complaint says that the prosecutor edited videos recorded by a conservative activist group to remove footage that could have helped clear the protesters of criminal charges. The charge says she edited videos to omit footage of protesters telling others to remain nonviolent and use de-escalation tactics with police. The charge says the prosecutor made false and misleading representations to the judges in the DC Superior Court and defense attorneys about the edits in the videos and how the government acquired them. And a judge in those cases found that she intentionally withheld evidence. That case is still being litigated, but it does not look good for her. So what's the ethical point here? It's not that representing Donald Trump is unethical. It's that there are dangers in getting wrapped up in any cause and losing perspective. We owe independent duties to the judicial system that require us to consider what we are arguing, no matter what our clients believe or how aggressive they demand we be. When we overstate what the evidence or law supports, we run the risk of facing dangers that we violated Rule 8.4, either because we are dishonest or because our conduct might be deemed detrimental to the system of justice. Sometimes those charges will be heard by sympathetic ears and we will get away with it, but not without time, cost, and embarrassment. But worse, like many of these folks, we can face ethical consequences and maybe our livelihood. Okay, speaking of Rule 8.4, I want to run quickly through some cases that have to do with other parts of that rule. Rule 8.4 is known as the catch-all rule because it has something like 8 different subsections, depending on what state you're in, addressing different issues. Here are 4 that have played roles in lawyers getting into trouble recently. In previous representations, we've discussed the emerging emphasis on Rule 8.4H, dealing with discriminatory conduct in practice. There have been a number of lawyers running afoul of that rule recently, a few of which we'll talk about. Okay. First up, a federal judge in Virginia has ordered that lawyers in a case before him explain why they should not be sanctioned for filing a document that he said included apparent fictitious cases and made up quotations, much like Amy and Jen have talked about. The lawyers argued that the errors were unintentional and stemmed from their good faith reliance on AI tools. They argued that an AI tool miscited 2 real cases, but the filing included quoted phrases that do not appear as quoted, but nonetheless accurately reflect principles discussed in those cases. The judge's order said that he could not find the cases and quotations through an independent review and asked the plaintiff's lawyers to show cause why they should not be referred to their state bar associations for professional misconduct. Of course, these aren't the first lawyers to be caught relying on AI, including our friend Michael Cohn, and unfortunately, they probably won't be the last. If you take one thing out of the 3 presentations today, it should be don't use AI for your legal citations. Next up, we have a repeat offender from Colorado. This guy is a gift to CLE presentations that just keeps giving. He was featured in our 2022 presentation on 8.4 because he was suspended for sending an email to his client, calling the judge on their case a big fat bag, and then charging clients an unreasonable fee based on time spent by his associate that wasn't licensed to practice in the state. Only a few weeks after that opinion came out, he was censured in a separate matter where he failed to deposit client funds into a trust account, violating Rule 1.15, and did not advise the client to seek independent legal counsel prior to entering into a business transaction with him, which violates Rule 1.8. His most recent problem arose when he sued another client over a fee dispute in which he made several more footfalls. First, a dispute arose around whether the client was properly served. The client's new lawyer had security camera footage that showed the process server had not actually served the former client. The lawyer here did not just ignore that evidence. He misrepresented to the court that proper service had been made and moved for default judgment. Then, while the dispute over service was going on, the lawyer saw the client out at dinner with a group of friends at the same spot where he was eating. The lawyer approached him, used an anti-gay slur against him, and some witnesses said he used the word black before the slur. Later that evening, the lawyer yelled at the client from across the room, "I will take your effing house." He followed up on that threat several days later, filing a writ of attachment against the house. But this lawyer forgot that the client he was yelling at about the case was represented and violated Rule 4.2. But wait, there's more. Later in the year, the lawyer posted a comment online saying he had sued the client for stiffing him on fees after a successful result and calling the client a dishonest crybaby. Again, social media, not always your friend. There he violated Rule 1.6 by revealing private information about his representation online. But wait, there's still more. In a separate complaint filed in May this year, the Office of Attorney Regulation accused the lawyer of attempting to circumvent the pending disciplinary complaint by this prior client by suggesting that he might settle the underlying fee dispute if the client withdrew the disciplinary charge. This, the complaint says, is conduct prejudicial to the administration of justice, violating Rule 8.4D. This one ended up settled, with the lawyer getting another suspension and 2 years probation. I think he got off easy, and I am looking forward to next year's presentation when we can talk about what he's done next. Okay, next, an ex-partner at Lewis Brisbois has sued the firm for racial discrimination, and in that suit, he specifically refers to a trove of emails between former practice leaders at the firm that were made public last year. After those lawyers left Lewis Brisbois to start their own firm, Lewis Brisbois disclosed dozens of internal emails between them that used racial, sexual, and homophobic slurs to describe firm colleagues and others. I haven't seen any charges filed about a violation of Rule 8.4 yet, even though such messages would be clear violations. But we know that the new firm lost many clients and lawyers as a result of the messages going public. So as I tell our folks all the time, emails never die and they pop up when you least want to see them. So don't write anything you don't want your coworkers or clients to read, even if it's not about them. Okay, next. A New York grievance committee opened an investigation of an attorney after he filed 3 complaints with the New York Human Rights Council containing racist and anti-Semitic language. When the Grievance Commission emailed the lawyer asking for a response to the misconduct allegations, his reply again used racist and anti-Semitic language. The commission then reviewed various court filings by the lawyer and other matters and found that he made anti-Semitic remarks and used foul and vile language to attack judges in those pleadings. The court hearing the complaint said that there does not appear to be any reported case in which an attorney's misconduct rose to the virulence that respondent has demonstrated before and throughout this disciplinary proceeding. Words fail to capture the severity and extent of his bigotry. The conduct here is simply shocking and outrageous. Then they disbarred him. The lawyer argues that he engaged in protected speech and appealed his disbarment. That's still pending. I don't like his odds. The Iowa Supreme Court reprimanded a former state prosecutor who was alleged to have made sexually explicit and derogatory comments while in office, including referring to judges as bitches when talking to his employees. He also used homophobic slur in front of one of his employees and told several off-color stories and jokes. Once again, the lawyer insisted that that this ruling violated his right to free speech under the First Amendment. The Iowa Supreme Court rejected that argument, as has every court that I'm aware of. In Illinois, a former federal prosecutor, president of the Federal Bar Association, and shareholder at Polsonelli got in hot water for making incendiary comments about judges, prosecutors, and Jewish people. He also demonstrated a pattern of hostility toward Jews in court filings and alleged the state's attorney was being controlled by a Jewish man. He later compared Cook County Sheriff's Department deputies to Nazis. He said his statements were taken out of context and justified anyway. The Illinois Supreme Court disagreed and suspended him from practice for 3 years. What's the theme here? People need to start thinking about what they put in. The kinds of comments that you would make with your friends from high school are not the kinds of comments that go in your communications as a lawyer. That seems obvious, but it's not apparently understood by everybody. There are more and more cases where these issues are coming up. Last time I gave this presentation, I had 2 or 3. This year, I probably had 20 to pick from. You guys got the cream of the crop. The point is, enforcement's coming. Be careful what you say and write. Okay, for our last example of failing to think before emailing, I want to talk briefly about a lawyer in California who thought issuing crazy, over-the-top tough guy threats would compel an insurance company and its lawyers to pay him and his clients a large stack of cash. It did not work out for him. I'm going to apologize in advance for the very graphic language used here, which might offend some, but these are actual court quotes from court filings, at least according to the article I read. This lawyer represented a couple seeking to recover from Allstate for a water loss that involved about $200,000 of damage. The lawyer made a series of increasing settlement demands. Eventually, the defense counsel told him that his $125 million demand was counterproductive in a case involving a $200,000 dispute. This lawyer was not happy about that, or most anything else, as far as I can tell. A motion for protective order was filed with the court, attaching a string of insulting and expletive-laden emails he sent to Allstate's counsels. They are classics, which I won't read out loud. This is, trust me, a very shortened version of the list. Some emails went beyond insults. He told one lawyer, "I know where you live," and said in another email that he would go batshit crazy on the lawyers. The judge in the case, who happens to be a former Marine, held a hearing and compelled the lawyer to appear and show cause why he should not be held in contempt. And as you might suspect, it did not go well for the lawyer. who, by the way, showed up late. The court started the hearing, talked to his former clients, who said they had no idea that he was telling the other side to eat a bowl of anything. When he finally appeared, actually what happened first was the judge said, "Where are you? Are you hiding here?" He was hiding, sitting in the back row. He had to come up and talk to the judge. He had filed an opposition where he argued that Allstate's motion was a desperate and improper attempt at gamesmanship intended to delay depositions and frustrate the administration of justice. He said the only evidence supporting it was hearsay, but of course, that's not hearsay, especially when the statements were in emails that were attached to the motion. He also argued that his statements, like everybody else, he argued that his statements, even if perhaps offensive, were protected by the First Amendment, by California's litigation privilege, and statutes protecting settlement communications. So there goes the First Amendment again. When the lawyer argued that the emails could not be authenticated, the judge said, "This is not the day to be cute. And you honestly believe the First Amendment extends to everything? You did go to law school, right?" The judge told the lawyer that the legal profession does not need him, and I'm going to do what I can to remove you from this profession. He was referred to the bar, and the charge ended up in a settled resolution that I couldn't find any details on. But again, the moral of the story is the enforcement is being ramped up. Bar associations and courts are not happy with the lack of civility, either inside the firms or in the courts, and ethical charges are coming for anybody that doesn't adhere to at least some modicum of professionalism. So that is the end of our presentation on 8.4.